Okay, looks like we're ready to go.
Good morning, Your Honor. May it please the court, Jeremy Bailey on behalf of Ms. Carrozza. May I reserve 5 minutes for rebuttal?
Yes, sir.
The central question in this case is whether Ms. Carrozza was the prevailing party in this litigation after she obtained nearly $68,000 in additional policy benefits that Frontline refused to pay.
But Mr. Bailey, was the suit necessary for her to accomplish what she ultimately accomplished? In other words, is that what she had to do? And as part of that question, did she not ever give the insurance company an opportunity to reconsider their original adjustment? Did she ever challenge it or present a new number before the suit was filed?
So 2 points on that, Your Honor. The first is one of the key issues in this case is that this wasn't just a roof claim that the carrier opened coverage for, and there was just a dispute as to the amount that should be paid to replace the roof. Frontline also denied any policy benefits for the interior, and this court has drawn the line between separate portions of the claim where you can have a coverage open for the roof but a denial for the windows and doors, right? You can have separate portions of the claim be open coverage and denials of coverage. This case involves the latter, where there was a denial of coverage. No dollars were paid for any of the interior damage that Ms. Carrozza suffered. Now, your Honor's correct. There's nothing in the record where Ms. Carrozza sent in an estimate saying, here's what I think, but the crux of the
company acknowledged coverage. The company did an adjustment. The company wrote a check, offered to pay, and at any time, was there any challenge to that? That, we've had, we have a different number. We had our own adjuster come up with a different number. Was there any of that before the suit was filed?
There's nothing in the record to that I could point Your Honor to regarding that. But
isn't that what has to happen? Because the suit has to be absolutely necessary for her to have accomplished what she accomplished. And if she didn't give the insurance company a chance to reconsider it or make it right before a suit was filed, how do we know that the suit was necessary?
Because when there's a denial, Your Honor, when the insurance company says we're not paying you any money for your interior damage, $0, no coverage is being open, she's entitled to take them at their word. There was nothing in their coverage opinion that said, please submit a competing estimate, or this is just what we've done based on what we have so far. If you think that we're wrong, please tell us so. There was nothing about that. They made their final decision. They denied coverage for the interior. They denied coverage for the screen enclosure, which isn't an issue here, and only opened coverage for a small portion on the roof. She was entitled to take them at their word that they weren't going to pay any additional money for this loss. And that's when she filed suit against Frontline. And when Frontline demanded appraisal, it was determined that she was owed an additional $68,000 in insurance benefits she would never have been able to obtain if she hadn't gone out and hired an attorney and incurred that cost and then filed a lawsuit.
Under the terms of the policy, wasn't she required to invoke the appraisal provision before filing suit?
No, Your Honor. And that's one of the ways that the trial court went astray in this case. It made 3 factual findings to support its grant of final judgment, and 2 of them involved the invocation of appraisal. In the appraisal provision, it's an option, just like mediation's an option. Either party had the option to invoke appraisal before filing a lawsuit. Neither party was required to invoke appraisal as a precondition to filing suit. Now, of course, after Frontline invoked the appraisal option, then it becomes mandatory. And that's what the policy says. It says that either party may invoke an option, but once either party does, both parties have to participate. And Ms. Carrozza did. And it was determined that she was owed $68,000 that the insurance company refused to pay pre-suit, including a reversal of the denial of coverage for $17,000 worth of interior benefits.
You made reference to the three points that the trial judge made in her order, and the second one is plaintiff did not provide defendant with any estimate setting forth plaintiff's position as to the amount of the loss of the subject insurance before suit. Wasn't she required to do that?
There's nothing in the policy, particularly in the case of a denial of coverage, that requires an insurer to submit a competing estimate of the loss as a condition preceded to filing suit. When
And
an
you know,
insurance
Mr.
company,
Bill, if I may, you keep saying that there was a denial of coverage. Help me out. Where in this record is there an affair that you could point me to that there was indeed a denial of coverage?
you have to look, if you compare the appraisal award and you compare the coverage decision, you'll see that on the appraisal award, the coverage A is broken out into its component
No, no,
elements.
no, not the appraiser. Let's set that aside because you're taking the position that they denied coverage and that's the reason why you file suit. And then by filing suit, it triggered the appraiser and so forth. Let's just set all that aside. Okay, because this is a summary judgment and the summary judgment. So where in the record can you affirmatively show me that there has been a denial of coverage before you file suit?
If you look at pages 228 to 230 of the record, you see the entire sum and substance of the insurance company's opening of coverage in this case. And in this case, they only opened coverage for the roof. They did not agree to pay any other policy benefits for any other portion of the policy that was damaged as a result of this loss. Their determination that they were only paying for a small portion of the roof was a denial to all of the other portions of the loss.
Aren't you taking a little bit of liberty with that? Because if the insurance assessed it a certain way, then they have no knowledge that you disagree with their assessment. They have no knowledge that you're taking the position that they have effectively denied coverage. And so I guess I'm missing something. In order for you to go forward, and this really goes back to what Chief Judge Morris was saying and Judge Black was saying, where in this record has there been any type of communication from you to the insurance company saying, hey, by you opening just this little thing on the roof, you are in effect denying coverage on everything else? Because when you look at the case law regarding the race to the courthouse, this is what they discuss. So please help me out. Where in this record has there been an affirmative denial of coverage?
There is no letter, Your Honor. There's no letter from Frontline saying we are, raising some type of exclusion in the policy to the interior damage. There's nothing in the policy like that. What happened in this case is that you have a homeowner that has hurricane damage to the roof, and the insurance company comes out and says in their letter, this is all we're going to pay. There's nothing in that letter that suggests they're willing to change their mind. There's nothing in that letter that suggests that they're willing to, or even asking for competing estimates. Very often you will see in these cases where insurance companies say, this is the best we've done based on the information we have to date. If you've got other information, send it to us. There's nothing in that letter that says anything like that. The insurance company had made its decision. It said it was only opening coverage for a small portion of the roof, and Ms. Carrozza was left with the option of what to do. And when she hired an attorney and brought suit, that was the first time that Frontline said, let's go to appraisal. Let's see if we can quantify the amount of policy benefits owed. In Frontline's
what they did at appraisal, once they saw your appraiser's evaluation, they agreed. They didn't argue, they agreed. And had that been presented to them pre-suit, they likely would have done the same thing.
With all due respect, Your Honor, I don't know that hypothetical situation, and we don't know how the appraisal process worked. All we can see from the record is the appraisal award that was agreed to by Ms. Carrozza's appraiser and Frontline's appraiser. We don't know.
Well, the key what you said is we don't know, and you're right about that. And we'll never know because your client didn't give the insurance company a chance to look at their numbers before suit was filed and say, gee, you got something here. We'll never know that. And that's what the law requires your client to have done if she wants to be the prevailing party and get attorney's fees after suit is filed.
Your Honor, in a case like this, where an insurance company goes out and does an inspection that doesn't include all the proper damages, that is exactly the type of a denial where the insured can look at the loss statement that's presented to them and know that if there's only coverage being opened for the roof, that is effectively a denial for the interior damage. And when Ms. Carrozza files this suit and then Frontline agrees or then pays $68,000 additional in policy benefits, that doesn't make Frontline the prevailing party to be entitled to final judgment in its favor, right? That may be an argument as to why the award of attorney's fees should be reduced, or there should, there are defenses to the amount of fees being claimed. But these cases, you look at them through the eyes of the insured when they receive the coverage opinion from the insurance company. And just like this court said in Synergy 1, the post-suit payment of an appraisal award doesn't erase the prior denial like it never happened. So there's nothing in the policy that says in order to bring suit against the insurance company, you got to go adjust the loss yourself. You got to go hire an inspector. You got to go hire an adjuster. You got to create this competing estimate just to get in the door. She was entitled to take them at their word that they were not paying her a dime in interior damage, and they were only paying about $1,700 after application of the deductible for the roof claim. This is the type of case where that is a denial sufficient to support an attorney's fees, where you don't need the back and forth, where this isn't a case where this was only a roof claim, the carrier opened up coverage for $10,000 and the homeowner thought it was $30,000, and the parties just needed to work it out pre-suit. There was determined to be $17,000 in interior damage that Frontline did not pay a dime for, did not open coverage for, and on their from pages 228 to 230, the entire house was measured, and not a single item of damage was opened coverage for that interior property of the house. That is the type of denial that defeats the race to the courthouse argument, where when insured has to retain counsel, has to do something to overcome the denial that's been given to them by the insurer that requires or is sufficient to support an award of an attorney's fees. But at the very least, this is not a case where Frontline should be considered the prevailing party and have final judgment entered in its favor. The three findings of fact that the court made, the first being that the plaintiff did not invoke the policy's appraisal provision. She wasn't required to. There was no affirmative obligation to invoke appraisal prior to filing suit. And the same with the third, that the suit was not necessary to submit this claim to appraisal. That wasn't her obligation. When the insurance company, who has the duty to adjust the loss, made its coverage decision, she was entitled to take them at their word. And as we discussed the second one, this wasn't a supplemental claim issue where she didn't submit a supplemental claim timely, or there was some issue with that. The trial court simply found that she did not, that the policy required her to submit an estimate as a condition filing suit, but there's nothing in the policy that requires that. The trial court's three findings are completely divorced from what the policy requires. The policy requires Frontline to adjust the claim and determine the amount of damages that are owed under the policy. The same thing if this matter had gone to a jury trial. Ms. Carrozza's only obligation would be to show that there was a loss within the policy period, and that Frontline would have the burden to show all of the exclusions. This was a case where there was an exclusion of the interior damages that are specifically itemized on the appraisal award that are noticeably absent from the pre-suit coverage decision. This wasn't a case where Ms. Carrozza was racing to the courthouse to run up an attorney's fee award. When Frontline denied the interior claim and only paid a small portion of the roof, what was she left to do? She had to go out and retain professionals at an expense to her that she wouldn't have had to incur if Frontline had paid all of the policy benefits owed in the first place. So, Your Honors, we'd ask that Your Honors reverse or remand this case for a determination as to Ms. Carrozza being the prevailing party in this lawsuit and an award of attorney's fees. Thank you.
Thank you, Mr. Bailey. Mr. Lima?
May it please the court. Good morning. My name is Paulo Lima, here on behalf of Frontline Insurance. I'll start with, there's been a word, denial of coverage gets thrown around quite loosely. If we go to page 333 of the record on appeal, that's Frontline's letter to the insured, Ms. Carrozza, and it says the breakdown of your payment is as follows: coverage A, dwelling, and it states the amount of the replacement cost value, takes away the deductible, and shows what the net payment is. So counsel just referred to a denial of coverage for interior, but there is no coverage for interior or coverage for roof. There is coverage A, dwelling, then there's coverage C, personal property, for example. The only portion of the claim that was denied, which is no longer an issue for reason I'll explain, is this screen enclosure. And as Frontline pointed out in its letter, it says you're not getting coverage for the screen enclosure because you didn't pay the premium to get the additional endorsement. And consequently, the screen enclosure was never appraised. As we can tell from the appraisal award, it says other coverages, coverage B, other structures, which is what screen enclosure would fall under, not appraised. So clearly that can't serve as the basis for a confession of judgment. So the only amount that was paid was payment for coverage A, dwelling, for which it is undisputed that Frontline acknowledged coverage from the get-go in its initial letter. And so what we have here is what we see throughout the case law. It's a plaintiff who submits a claim, the insurer acknowledges coverage, issues a payment. At that point, it becomes incumbent on the plaintiff or the insured to at least come forward and say, wait a minute, this isn't enough money. Or ideally, here's a competing estimate, which you see all of the time in the case law. My public adjuster says it's $100,000, not $10,000. At that point, you have a concrete amount of loss dispute. And then if the insurer does not at least pay more money or invoke appraisal, then the insured would be forced to sue, which under this court's case law, which we've cited in the brief ad nauseum, that is what's necessary. You need a dispute in the amount of loss before the insured can run out and file a lawsuit. Because think about the alternative. You submit a claim to your insurer, the insurer cuts you a big check, assumes that you're happy with that check, you say nothing. Year later, which is what happened here, plaintiff runs out and files a lawsuit and says, okay, now if I get another dime, I get a couple $100,000 in attorney's fees. And that is precisely what the case law holds is what no longer entitles the insured to recover their fees. As Judge Altenburn explained it very nicely in Hill, when he wrote, it is only when the claims adjusting process breaks down and the parties are no longer working to resolve the claim within the contract, but are actually taking steps that breach the contract, that the insured may be entitled to an award of fees under 627, 428 Florida statutes. And that's exactly what happened here. There was never any breakdown. The moment that Frontline became aware that there had been that there was a dispute is when it received the lawsuit. 20 days later, 20 days after it gets served, it invokes appraisal. They go to appraisal, they pay more. And at that point, the appraisal process is precisely what the policy envisions as the mechanism for resolving an amount of loss dispute. And that's exactly how it worked, exactly the way it was supposed to work. There's been, in the briefing at least, plaintiffs cited, I didn't hear him raise it now, but I guess I'll address it affirmatively, the Supreme Court's Johnson versus Omega Insurance decision in 2016. Plaintiffs argued in the reply brief that, well, you know, ever since Johnson, all of that forced to sue or race to the courthouse case law has been wiped away. And that all that's required is a post-suit payment. And under Johnson, if there is a post-suit payment, no matter what, then the insured is entitled to attorney's fees. If you look at Johnson, of course, it's distinguishable because in Johnson, there was a total and complete denial of coverage. And it's a sinkhole claim. In Johnson, the insurer completely denied coverage. At that point, the insured had no choice to recover under the policy or to get coverage, but to file a lawsuit. And so the question that the Supreme Court addressed in Johnson was whether where there's been a total denial of coverage, not a partial payment, but a total denial of coverage, does the insured have to show some element of wrongful or bad faith conduct in order to be entitled to fees? And the Supreme Court answered that by saying no. If there's a complete denial, then the insured has no choice but to file suit. That's what has to happen. And we know that the Johnson has not affected the force to sue case law because we see tons of state and federal court cases post Johnson that discuss Johnson and yet continue to apply the force to sue doctrine. A great example is Bryant versus Giavera. It's a 4th DCA case in 2019 where the 4th District discusses the holding of Johnson. It then says, quote, even after Johnson, not all post-suit payments by an insurer will constitute a confession of judgment. We recently held that where an insurer valued a loss, issued payment, and was unaware of the insured's disagreement with the damage valuation until the filing of the complaint, the insurer's timely payment of an appraisal award during the litigation did not constitute a confession of judgment that the insurer breached the insurance policy. And the case that Bryant is referring to, the prior holding, is Goldman versus Usaa, which is a case that we've cited in our brief and we've discussed, where the facts are directly on point to this case. You have a lawsuit that gets filed without any disagreement arising. The insurer invokes appraisal, the insurer pays the appraisal award, and then when the plaintiff attempted to get their fees, the 4th District said, no, you're not entitled to your fees because you weren't forced to sue. Then goes on to address Johnson because in Goldman, the insured made the same argument that Ms. Carrozza makes here, and the court in Goldman very easily distinguished it the same way I just distinguished it by saying, but Johnson is inapplicable. In Johnson, the insurer denied the homeowner's claim in its entirety, leaving the homeowner with few options other than a lawsuit. So we've got the 4th District distinguishing Johnson. There's also, frankly, 2 11th Circuit Court of Appeals, federal appellate courts, applying Johnson and distinguishing Johnson on the same basis. And in fact, interestingly enough, in the 2 cases that I'll cite to the court, the insured's counsel was the same firm that is representing Ms. Carrozza in this appeal. One of those cases is JPFD Investment Corp versus United Specialty Insurance Company. It's 2019 in the 11th Circuit, where the court held, we do not read Johnson to say that an insured is entitled to attorney's fees under the statute whenever a suit is filed and the insurer subsequently pays an additional benefits, regardless of whether the insured suit was necessary to obtain the additional benefits due under the policy. Another case by the 11th Circuit, same plaintiff's counsel, was Stan versus First Liberty Insurance Corp, 2021. And in that case, the 11th Circuit discusses Johnson and states, quote, it is simply not the case that the confession of judgment doctrine applies whenever the plaintiff sues an insurer and money is later paid. So I think we've established that the doctrine still applies and that here, under the facts of this case, Ms. Carrozza was not forced to sue. And so the question then becomes, well, did the trial court err in granting summary judgment for Frontline and denying plaintiff's motion for summary judgment, wherein she sought entitlement to fees? Now, we've submitted last week as supplemental authority this court's recent opinion in Synergy 2. Hopefully the court has had a chance to review that, because both Synergy 1 and Synergy 2 are insurance cases where the court recognized that, again, when there has been a post-suit payment of an appraisal award, the insurance company is completely entitled to challenge the plaintiff's entitlement to attorney's fees under the, what I call forced to sue. In the decisions, they call it the race to the courthouse doctrine, essentially the same thing. So here in the Synergy cases, there's a little bit of a wrinkle here that's important. In both Synergy cases, the plaintiff did not, or the issue of the plaintiff's entitlement to attorney's fees was never adjudicated. In Synergy 1, the plaintiff never moved for attorney's fees. In Synergy 2, the court never ruled on the plaintiff's motions for attorney's fees and expressly reserved jurisdiction to decide entitlement to fees. And so what happened in both of those cases is the court held that, well, there's been a post-suit payment. The insurer is not entitled to a summary judgment because the fee issue remains outstanding. So they vacated the judgment. remanded to the trial court to determine the fee issue. That's not what we need here, because here it's uncontroverted that the fee issue, the plaintiff's fee issue, was very clearly ruled upon. The plaintiff's motion for final summary judgment expressly stated at page 453 of the record that based on the defendant's post-suit confession, plaintiff is the prevailing party under section 627-428 and is entitled to attorney's fees and costs. The order on cross motions for summary judgment then expressly makes findings that, as Judge Black pointed out, I think, it was not necessary for the plaintiff to initiate this lawsuit in order to submit the subject claim to the appraisal panel. Then went on to say, accordingly, plaintiff's motion for summary judgment is denied. And then the final judgment states, of course, plaintiff shall take nothing by this action and does not reserve jurisdiction to award fees and costs. And so therefore, the issue's dead. It's been ruled upon, it's complete. In fact, as this court has seen from the briefing, that really was the focus of the briefing in this court, was plaintiff's entitlement to fees, whether or not they were forced to file suit. Unlike in the synergy cases, that's been completely decided below and has been fully briefed and presented here. And therefore, the court should affirm that portion of it. And because the plaintiff was not forced to sue, and because plaintiff's entitlement to fees has been rejected already, that's the distinction where synergy, where Frontline is entitled to a summary judgment. There is no reason to vacate the judgment and remand for further proceedings. The case is done. All of the outstanding issues have been addressed, and therefore, Frontline's summary judgment should be affirmed. And tellingly, that's exactly what happened in Goldman, the fourth DCA case, which I discussed earlier, which is squarely on point factually. The fourth district affirmed the order denying the plaintiff's entitlement to fees, as well as the summary judgment in favor of the insurer in that case. There's been some, last point, some briefing about the sufficiency of the affidavit that was submitted in support of Frontline's motion. First of all, that argument can be very quickly dispensed with because it was not preserved below. The plaintiff never filed a response to Frontline's motion for summary judgment, did not file a competing affidavit, and in fact, in plaintiff's affirmative motion for summary judgment, could have, but did not raise any issue challenging the sufficiency of Frontline's affidavit. And then, even if the court were to determine or reach the merits, the affidavit was clearly sufficient. It sets forth the basis for the employee's knowledge. She's an employee of Frontline. She reviewed the claim file, Ms. Carrozza's claim file. And based on that review, there is no evidence that the plaintiff either submitted any correspondence advising Frontline of a disagreement with the claim decision or any competing estimate. Now, I know that counsel has said, well, we're in the policy doesn't require a competing estimate. It does not, but the case law does require, if not a competing estimate, at least some indication that there's been a dispute. And of course, there has been no such indication. If plaintiff wanted to get past summary judgment and contest the Burton affidavit, she would have had to at least raise some argument below that it was insufficient, or ideally submit her own affidavit saying that, well, I did submit an estimate, or I did raise a challenge to the sufficiency of the payment or the claim decision. Never submitted, and so I will stop talking. For those reasons, we ask that the court affirm the judgment in its entirety. Unless the court has any further questions. Thank you.
Thank you, Mr. Lima. Mr. Bailey, you have 5 more minutes.
Your Honors, I just 2 quick points on rebuttal, may it please the court. The issue in this case turns on whether there was a portion of this claim that was denied by Frontline. And I'd ask your Honors to review the pre-suit coverage analysis at page 221 of the record with the post-appraisal coverage analysis at 427 of the record. And what your Honors will notice is that this is in the post-suit, post-appraisal coverage analysis. There wasn't one line item that said coverage A, payment. In its post-suit coverage analysis, it broke out coverage A under the various component parts of the dwelling roof and the dwelling interior. Of course, we've discussed before that the dwelling interior portion of that was completely denied pre-suit. But even more importantly, at the bottom of that letter on page 428 of the record, there's a paragraph where Frontline says that it's making this payment under a full reservation of rights. It's continuing to contest all coverage issues raised in the pending action. It's only making this payment to foreclose any allegation of bad faith and further avoid any allegation of breach of contract. And then, quote, First Protective further affirmatively avers that it intends to pursue its coverage defenses and to dispute liability for all aspects of this claim, which remain unresolved. Payment herein is tender without waiver of coverage defenses under the policy or at law. And it then goes on to discuss it will seek recoup of those funds. This wasn't a case where there was never any denial, never any contesting of benefits owed, and this was just an amount in dispute case. That's not this case. Frontline specifically told Ms. Carrozza at the beginning, $0 were being paid for the interior, and then after an appraisal award was entered, that it was going to continue to litigate those coverage issues until this case was finally decided. That's what this case is about. That's why Ms. Carrozza filed a lawsuit, and that's why Ms. Carrozza, after defeating all of those issues, should be determined to be the prevailing party in this case. And the second point I wanted to make just briefly is that my colleague mentioned that it's incumbent upon the insured to submit a competing estimate as a precondition to filing suit, but then agrees that there's nothing in the policy that says that. If there's nothing in the policy that says Ms. Carrozza has to submit a competing estimate as a condition to filing suit, she was free to bring this suit the moment she received the coverage decision from Frontline, only paying a portion of the damages to the roof and completely denying the coverage for the interior. Thank you.
Thank you both. Thank you very much. Have a good day, gentlemen.
Thank you, Your Honors.
Our next case is City of Northport, Florida versus West Villagers for Responsible Government and